Am I audible to you? Is there anyone testing the sound?
So you're
Uh,
audible, sir.
Great, thanks.
Good morning, brother.
Hello. Hi.
Good morning.
You
Am I audible?
car में से? Why? What
आवाज आ रही
happened?
है?
Yes, you are audible. You are in car.
I'm in car and I believe we are on the screen.
You can blur the background if I'm not wrong.
It is not happening. Let it
Okay.
be.
Anyhow, have you read the proposition?
Yes, I think let's keep these personal things personal because we may be on the screen.
No, no.
So
I'm
this is
asking. I'm asking
uh,
about the proposition. Have you read that?
Yeah, I've gone through. I've gone through.
Okay.
sir, if I may.
Yes, please.
Yes, yes, go ahead.
So we are
Yes.
currently live on YouTube through the channel of the college.
Okay. So we'll just pause here. Don't worry.
Yes, sir. Good morning, everyone. We will be beginning shortly.
Photum reader, can you just confirm if I am absolutely audible and is my picture clear?
Yes, sir, you're audible and your picture is absolutely clear, sir.
Okay. All right. Thank you.
Good morning, respected judges, dear participants, faculty members, and live stream viewers. Welcome to the 12th National RCL Moot Court Competition 2024. After various rounds of screenings and grillings, two teams have qualified for the finals, and only one shall come out meritorious. Before we begin, I shall read out some rules and regulations. Each team has two pre-appointed speakers who have remained the same in all the rounds. Each team will get a total of 30 minutes, including time for rebuttal and sub-rebuttal. Any extension of time shall be subject to the discretion of the judges. The division of the time between the speakers is the discretion of the team members, subject to a minimum of 12 minutes for one speaker, including rebuttal. I will be indicating to the participants and the judges when the speaker is left with 7 minutes, 5 minutes, 2 minutes, and when the time has lapsed. The speakers are required to tell the division of the time before the commencement of the round to the respected judges and the readers. Uh, Teams, kindly please help me note down your division for the time.
Hello to the dear organizers. Our timing would be 14 minutes each per hit and 2 minutes reverse reserved for the rebuttals. Thank you.
TC 40.
Our timing would also be 14 minutes each per speaker and 2 minutes reserved for us a rebuttal.
All right. Thank you and wish you all the best.
So we know the teams by the name TC35 and TC40, right?
Yes, sir.
And TC35 is for the motion or against it?
Sita sir, your audio is breaking. So which team is going to start first?
Am I audible now?
Yes, sir.
Yes.
So, if I could answer to sir's question.
Yes, which team is starting with the first?
T35 is for the petitioner, sir.
So you are arguing against the legislation.
Yes, sir. We're arguing against the legislation.
You're praying for the quashing of the controversial legislation, basically.
Yes, sir.
Okay. With permission of my learned friends, Sitaji and Ajaypalji, can we skip the facts narration and come to the straight legal points, basically?
Yes, it is up to the reader. Even I was of the same view. Let us straight away, because they've already reiterated those in the earlier rounds.
Yes. So we need not know the facts. We are aware. As far as, if I may sum up for all of us, I think we are looking at the legality of a legislation which comes in crossroads with Article 25, right to religious practices, and the state's view of uh,
Basically,
state's view
state
of
wants to introduce.
preventing the misuse of that liberty. Am I correct?
Yes, sir.
All right, you can begin.
The council seeks permission to approach the dais.
So all permissions are granted. Need not ask any permissions. All permissions are granted to you.
Much obliged, Your Lordship. So, with Your Lordship's permission, I will address issue 1 and issue 4 together, as both involve the unconstitutional restrictions imposed by the Act on voluntary religious conversions and petitioner's right to marry. And my co-counsel.
Can you summarize issue 1 for us? What is issue number 1 for you?
Yes, sir. Issue 1 is about the fundamental rights violation, especially in context of voluntary conversions. That is what the issue 1 says, sir.
And what is issue 4?
Issue 4 is basically about the state's intervention in the aspects of personal matters like religious beliefs.
Okay.
Much obliged.
Please start.
Much obliged. So if the bench is satisfied with the perusal of the fact, the council is seeking permission to move on to the jurisdiction of the case.
No, we are trying. No, need not reiterate the jurisdiction. Come straight away to your issue. That is how this legislation is violative of the fundamental right as enshrined under Article 25.
Sorry, Your Lordship. I will keep that in mind. Thank you.
Please.
So, if it may please Your Lordship, I, appearing on behalf of the petitioner, will address the unconstitutionality of the Prohibition of Unlawful Conversion of 2024, Religion Act 2024, in three folds. Firstly, as to the infringement on the fundamental rights to freedom of religion under Article 25. Second fold, the arbitrary restrictions imposed by the Act without any legitimate state interest. And thirdly, the violation of constitutional morality and personal autonomy, allowing excessive state interference in private religious decision. It is humbly submitted that Article 25, Clause 1 of the Constitution of Bharat provides every citizen the right to practice, profess, and propagate religion. Article 25, Clause 2, as we all know, also places certain reasonable restrictions on the same. But
kindly read the bare provision, Article 25.2. What's the language of Article 25.2? Read that.
Article 25.2. I request you a few minutes, Your Honor.
Do you have a bare act with you?
Yes, sir. We have
Read the
copy.
Article 25.2.
Yes, sir. 25, Clause 2. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practices. B is providing for social welfare and reform or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. This is as the Constitution as read.
Councils, just I think in your memorial, what I have seen is you have cited Indian Young Lawyers of Sabrimala Temple verdict.
Yes, Your Honor.
But as I know Sabrimala, one important paragraph is there in, if you do you have the judgment with you?
Sabrimala judgment. Yes, sir. I can make
So
that.
I am reading the SCC basically.
Okay.
So the court has said that conversion, like, let me read the word. This would show that if one were to propagate one religion in such a manner as to convert a person of another religion faith, such conversion would clash with other person's right to freedom of conscience and would therefore be interdicted. This is an observation of Honorable Supreme Court that conversion itself is not within the ambit of right as established in Article 25. So what is the objection? Tell me the legality. How do you come out of how the law is illegal in view of the observation of Honorable Supreme Court, which excludes conversion out of Article 25?
Indeed, Your Lordship, that is a question that we were trying to answer. So, for this, I would like to cite the council would like to cite a case law, that is Reverend Stainless versus State of Madhya Pradesh, wherein it has been held by the Honorable Court that right to conversion is an integral part of Article 25. But
Where is that judgment? Is there? It is cited in your memorial.
Reverend Stainless, yes, sir, it is cited in our memorial.
Tell me the page number.
Yes, sir, definitely. We request a few minutes. Sorry for the delay.
They should be ready with you. Haven't you read
Yes.
the memorial? You haven't prepared
Yes.
it.
No, sir. We have the memorial ready. We just need to look
Yes,
into
then
the
cite it.
page. Yes, sir, definitely.
It's not cited in your memorial, if I'm not wrong. State of Madhya Pradesh.
Sir,
It's
then,
it's there in the citation, but you haven't reproduced the text, if I'm not wrong.
yes, sir. Sorry for the confusion.
So unless you can have the text of the judgment, you have to read us the text of the judgment. We don't need a commentary on it.
Okay, sir. Text of
So, Harish, are you telling me that they have reproduced it somewhere?
No,
Or you
they
telling me
haven't. They haven't reproduced it.
that it is in the table of cases, right?
But they just have included in the list of citations.
Okay, sir. We're sorry for the inconvenience.
No, it's not
No,
about convenience, counsel. We don't have any. We are very convenient. But if you're citing a law,
Yes, sir.
we need to know the exact wording, how the law works. This is not the way that you just speak that in such judgment it has happened. How do we know what has happened? Case Putta Swami is also another judgment which protected whereby it does help you in a way. But in view of the Sabrimala verdict, where the religious conversion has been outrightly held to be not a part of the protection granted by Article 25. Now, if there is an exception to it, you have to justify it to us.
Yes, sir. So though we haven't outrightly said have reproduced reference Stainless versus State of Madhya Pradesh in our memo, we from the judgment of the court in this particular case, we would like to talk about. In this case, they have told there is a key passage from the judgment that states that Article 25 guarantees the right to profess, practice, and propagate religion, but it does not grant the right to convert others forcibly. This is an excerpt from the judgment, sir. The
So
court
that is the intention of legislature. I mean, that is what the law is about. It
yes,
is merely asking you to declare that you intend to convert to some religion. The state wants to be sure of the fact that it's not a forcible conversion. What is wrong with the law?
sir, the problem, indeed, Your Honor, that is a question that we would, we want to bring it into your notice. Sir, there is no problem as such in knowing whether it is forcibly done or not forcibly done, but voluntary conversion is a facet of freedom of religion under the freedom of conscience guaranteed by the constitution. So Article 25 protects this right to voluntary convert as part of it also. In the case of Aruna Roy versus Union of India, the Honorable Supreme Court highlighted that while the state can regulate religious conduct for the sake of public welfare, it cannot unduly interfere in personal religious beliefs. The prohibition of unlawful conversion of religion act goes beyond the constitutional bounds by interfering with personal religious decision without justifiable reason. Additionally, the International Covenant on Civil and Political Rights, to which India is signatory, protects the right to change religion under
Are they
Article
binding
18.
on us?
It has a persuasive value, sir.
Has that been ratified into legislation?
Ratified into this particular legislation.
If you are citing an international convention, you have to be sure first whether it has been ratified into a law here or not. Unless it is ratified into a law, how it is binding upon us.
Much obliged, Your Honor, for the question.
Yes.
Yes.
So your primary argument, what I could understand, is that you are saying it does interfere with the privacy part. That is your larger
sir.
argument.
Yes.
Whatever my learned friend want to ask with regard to this issue, they can ask. I'm fine.
Much obliged.
TC 35, we want to also understand from the facts, a little bit about the facts. You can start from there. Just
Yes,
in 1 minute, wrap it up in your own words. Don't look down, just wrap it up in your own words.
Oh, Definitely, sir. So, the petitioners, Alex and Taylors, were in a committed interfaith relationship for a considerable amount of time, and they were ready to get married. And that is when they decided, when Alex decided to convert his religion. Now, when Alex tried to convert, as per this act, they're supposed to go through an inquiry process and submit a written declaration as to their conversion, both of which was willfully done by Alex. Now, during the period of inquiry process, what happened is that Alex's parents alleged that there has been undue influence or allurement that has happened. That's the reason why this particular person has converted, and it is not on willingness, genuine willingness. So that is the contention that was raised by by Alex's parents. Now, Alexis, based on this and district magistrate inquiry process, the conversion was not upheld valid, and that is and aggrieved by this, they had approached the Banu Pradesh, the High Court of Banu Pradesh, and wherein the constitutional validity of the act was upheld, and there were charges levied against them. Aggrieved by this, they have approached the Supreme Court of India. This is the facts of your case, Your Lordship.
What do you have to say about issue number 4 about state intervention? You're dealing with the issue number 4 also.
Yes, yes, definitely. Much obliged, Your Honor. Under
Harish, I'm sorry.
Yes,
Before
please,
going
please.
to issue 4, so can you please read out the last line in the issue 1?
last line of the issue 1.
Can you read out the issue number 1
Yes.
towards the end? The
Yes.
last end.
Yes, definitely, Your Lordship. Issue number 1 talks about particularly in the context of voluntary religious conversion, whether Article 25 is infringed.
So what is your take about this issue, about this particular query vis-a-vis the facts of the case?
Indeed, Your Lordship. So, in the context of it, my contention, the council's contention is that it definitely violates Article 25 of the individual in the context of voluntary conversions. Because while such legislation is brought in, the state is raising a mere suspicion on all conversions at a basic level. So, because of mere suspicion, the state cannot interfere into such private religious matters of an individual. The Supreme Court, in the case of Rangarajan,
So council is regulating same as interfering.
Regulating, much obliged, Your Honor. Indeed, that's the question that we would love to give our opinions on. The issue here is regulating and suspicion. If the state is ready to raise suspicion on such aspects, then the state can interfere on everything. Suspicion can be arised on everything and anything, even in an arranged
Then I'll rephrase my question. If you're going to suspicion, then verifying and raising a suspicion are the same. These are two different aspects. If you are regulating, you have to verify, right? Here you are saying that it was a voluntary religious conversion, but from the facts, what I see, it is not a voluntary. It is a coerced.
Your Lordship, indeed. What is coerced or what is allurement is another issue with this particular piece of legislation. The term allurement has been used in a very vague manner, because allurement, as per the vagueness of the term allurement, or vagueness of a term in a legislation as delicate as this, leads on to further confusions as such. Say, for example, in Kartar Singh versus Union of India, they have said that if there is a word as such allurement or any such vague sentences, then that will create a chilling effect.
Council, yes. Citing law without context is just not appropriate in a court. Every precedent is backed by certain facts. Unless you know the facts, don't just say they said that. Tell us, in that case, this was the similarity. If the facts of a case are similar, then you can cite it, because without context, the citation is just not working for you in your favor. Now, what my learned friend is saying, let me elaborate it with an example. There are many instances in this country where people they are having extramarital affairs just in case they want to marry the other person, Hindus, but primarily, they converted into Mohammedan religion just to get married, and they changed their faith. Now, is that a conscious conversion, or it's an outrightly bad faith conversion, as I would say? Just state what I feel is state is just trying to avoid those situations where such misuse of liberty, misuse of that personal space can be prevented, and it can lead to social frictions. That is where I think my learned friend's query came from. So you have to answer now my learned friend's query, that what is bad in regulating after all?
Indeed, Your Lordship, there is nothing wrong with regulating, but the methods which is used in regulating is way too intrusive into the personal life of the individuals, of the citizens. When it comes to interfaith marriages, already the couple who's decided to go through an interfaith marriage is facing social stigma, societal stigma. On top of that, when a judicial intervention of such manner is done, it is further, putting them under a suspicious manner, and their right to freedom of expression, right to choose, right to union, and right to religious freedom, all of this is infringed. And as per the
Learned Council, you are saying that if two people coming from different religions, they want to get married, so there are separate provisions, separate protections granted under our laws for them. There are special marriages act that they need not convert. What my brother Harish he just pointed out to you, the reason why state has enacted this legislation is to check that whether the conversion is a genuine one, or it is for just for the sake of convenience for getting married and getting all the benefits that come around with it. If they're truly in love, if they truly want to spend their time together, it's not just for the one person to convert to the another religion. They can simply remain in their own religions. They can get married under special marriages act. There is no need. So that is why, how does this particular enactment, which is trying to regulate the bad faith conversions, as Brother Judge Harish has recently pointed it out to you, how is it bad, and how is it infringing upon the voluntary? This, because I pointed it out to you, it is not a voluntary conversion. It is a conversion for your own sake of convenience. She is not interested in becoming a Hindu or a Sikh. She's only interested that she gets married to a particular person. That's all.
Indeed,
so that is not a voluntary conversion.
Indeed, Your Lordship, I beg to differ on that aspect, because it is a voluntary conversion, because they are they are people who have their personal conviction and personal liberty, who told that I am ready to convert into this particular religion, and they are a majority. They've hit their majority. They're 18 plus individuals who have their own personal values, belief system, and everything. Based on that, they're saying that I am ready to convert into this particular religion. So now, when the state is interfering into something of such personal,
but Learned Council, but she's also remained unemployed for last 6 months. Now she's getting a job, she's getting a business, she's getting a good raise, and plus on the plus side is she gets to marry the person of her choice. So this is not a voluntary decision. This is based on the allurements, which is based on the incentives she's got.
Yes, I again beg to differ on this point, that indeed it's a great question, Your Lordship. But the
anyways, I believe we've taken enough of your time on issue number one.
Yes.
Otherwise, you won't be left with the
So
issue number
just
two.
just in last 20 seconds, your add me something up to it. Your primary argument is the privacy argument, that it violates your privacy argument. Is there anything you want to add to it?
Your Lordship, I would like to add the point of constitutional morality.
What is that? Don't go into the terrain which you are not even clear of. Just okay. We are taking 2 minutes of your co-speaker's time. I would ask reader to deduct 2 minutes. Now come what the constitutional morality is. Tell me what it is. Define it in 2 minutes. We are taking away from other speakers' time.
Definitely, Your Lordship. Constitutional morality, there are certain constitutional values that is upheld by the Supreme Court, such as individual autonomy, personal liberty. All of these are certain constitutional moral values that must be upheld by the Supreme Court. Hence, in this case,
what are those traits. What are those values? Number them. Tell me five of them. What are those enumerated morality, constitutional morality principles? Number them. 1, 2, 3. I don't need explanations.
Okay. Personal autonomy, individual liberty.
They are the same.
I'm sorry, Your Lordship. Freedom of expression, personal liberty.
They fall into the personal liberty space. I am saying what are other values to other traits of constitutional morality.
Rule of law, preamble.
Preamble is a constitutional morality.
The values that is instilled in the preamble must be
So I'm
upheld.
asking about those values only. Anyhow.
Social justice, equality.
Speaker one, I'm giving you a lifeline. You have cited a judgment of Shreya Singhal, right?
Yes, Your Lordship.
I want to know which law was struck down in Shreya Singhal.
IT, Information Technology Act.
Which section? Without looking. Till the time you look into my eyes, I can.
66.
60?
6A. 66A.
All right.
Anyways, counsel, this is, I think, read constitutional morality before saying larger things on it. You have cited the word constitutional morality. I think that you are so ill prepared on that word. Don't use such terms unless you have properly researched on it. On privacy aspect, you are there. We are taking your argument on the face of it. Now I'll ask your co-speaker to address your other issues, please.
Indeed, Your Lordship. It was a pleasure arguing before this speech.
If Your Lordships shall permit, the
Yes,
council...
all permissions are there. Tell me the issues. Just enumerate 2 issues which you are going to deal with.
Much obliged, Your Lordship. The council shall delve upon issues 2 and 3, through which the council is here to establish for issue 2 that the sections 8 and 9 of the Prohibition of Unlawful Conversion of Religion Act are outrightly violative of Article 21 under right to life and personal liberty and right to privacy. The second fold, which is on issue 3, we're here to establish that the mandatory inquiry process and the burden of proof, the provisions pertaining to both of these aspects, are violative of the principles of natural justice. If the bench shall permit, the council would like to advance arguments on the issue.
All permissions are there already, I told you.
Much obliged, Your Lordship. Before the council advances arguments on the issue, the council would first like to elaborate on what exactly Article 21 is. Protection of life and personal liberty. No person shall be deprived of the right to life and personal liberty except according to the procedure established by law. Now, herein we have sections 8 and 9.
Council, we are aware of the Article 21. We just want to know how in this particular case it fits. So you can skip this, Yes, proceed further.
Much obliged, Your Lordship. The sections 8 and 9, if I must touch upon them first. Through section 8, a declaration is sought for, which must be provided 60 days prior to the planned conversion. Secondly, through section 9, there has been brought out a mandatory inquiry process, which is being subjected upon all persons converting, performing a conversion ceremony. They must be providing for this declaration through section 8 and the inquiry process. Through this inquiry process, it is the district magistrate that shall grant permission for the conversion. Now, first fold, the petitioner herein would like to submit that the conversion herein is voluntary. To just emphasize on this, the council seeks the attention of the bench towards para 2 of the proposition. The first line of the para may be considered to say that the conversion is involuntary by saying that he chose to it was his personal choice to convert, but it may be argued upon that it is the reason of uniting with his partner that he converted. But it is herein that the council would like to establish that the same para emphasize on the fact that he willfully chose to perform a private ceremony to convert, and he took up this name Jordan, which in itself emphasizes that there was an element of interest, bona fide faith, and willfulness from the end of the petitioner to convert into a religion that they were not biologically a part of.
Council,
want
council, you have to please. Article 21 is not an absolute right. It comes with its own restrictions, as has been constitutionally held. Article 21 provides for exceptions on procedure established by law. This is an old understanding of the constitutional law, I think. Now, what state intends to do is, let me lay it down for you. It wants to just establish a procedure whereby state is at least sure of the fact that none of the conversion are happening out of allurements. It is voluntary.
yes,
Now, we entire Punjab is railing under the controversy of conversions by one religion of lower castes. If you are aware of, if you read newspapers and all, you must be aware of those controversies surrounding them. I don't want to name the faith, but that is happening. Now, the castes and the social categories on margins are offered jobs and something like that, as in the cases. Now, you tell me, I put it on you. What can be done to ascertain? What should be the procedure to ascertain that the conversion is voluntary? Or you are saying this procedure or the state's act itself is completely unconstitutional? Are you saying the liberty exists in absolution? That is the question to you.
much obliged, Your Lordship. First, I would answer this question in two folds before I conclude whether I am here to establish that the whole act is unconstitutional or is it the limit of sections that we are herein to answer upon. Firstly, in regard to the aspect that how to mark a line of difference between willful conversions and involuntary conversions, the act as such does not elaborate upon any definition for what willful conversions are, but to go by an understanding of how to interpret that a person has willfully chosen, we could observe upon certain criterias which the council would like to suggest.
Yes.
Basically, firstly, that the customs of another. I'd like to start from this perspective that every person is biologically born into a religion through the accidents of birth. Thus, it is not them who choose the religion that they belong to or they are associated upon. And for the religion that they associate themselves to upon birth, there is no procedural formalities to enter into, or there is no registration or any criteria. And at the same time, there is no consent of the person because it's mere accidents of birth. But because it's an accident of birth, it is also naturally possible that any person would have an opinion or may feel that their reasonable expectations in regard to spiritual perspectives are not being completely fulfilled through the religion that they are biologically born into, which is where there is a possibility that they may wish to convert into another religion. Now, when this occurs, the aspect herein is that the Law Commission of India, in its 235th report in para 4, had also emphasized that it is hard to outrightly provide reasons for conversion because it is their personal belief, and beliefs are pretty much subjective in itself. Because what the reason that an individual may associate towards converting to from one religion to another may not just limit to the fact that they're not the reasonable expectation from their biological religion is not satisfied. It's also possible that a religion that they enter into, they convert and enter into, may they may be of the opinion that that is satisfying their
Speaker 2.
expectations
Now,
and aspirations, legitimate aspirations.
we are appreciating. This is a good argument. I think we are asking
Harish,
your
can I
opposite
take it
team
over?
to the fact that in fact by birth your caste and religion is sort of imposed upon a child or a child when he's born. We would like to hear on this aspect from your opposite speaker, that why not a person, after understanding the nuances of another religion, should not have a liberty to choose that religion that is there. Okay, my
Speaker
learned
2.
friend is stating something to
Speaker
you,
2.
please.
Speaker 2, can you hear me?
Yes, your lordship.
So I want you to give me a brief summary of the various points on which you deem it appropriate that we should strike down this law.
Yes.
Just summarize them.
Summarize them, yes, please.
Your lordship,
Pointer. We just want
should I
pointer.
Should I summarize these pointers inclusive of both issues 2 and 3 conclusively?
Yes,
Or
Yes. Do that. Do that.
Do it.
much obliged, Your Lordship. With regard to issue 2, the law is outrightly violative of right to privacy. The right to privacy, it is violative of, as also advanced upon by my learned co-counsel. As every and conjunctively, if Article 19 is read with 21 and 14, as I already mentioned, that the
Just
procedure
one second.
alone. Yes, Your Lordship.
Okay. Carry on.
If I may continue, Your Lordship.
Yes.
Yes,
Please.
Much obliged, Your Lordship. The Article 19 under
You may.
I am not able to hear Your Lordship speak. There's some voice break from my end. From me.
When the voice breaks, you continue. Carry on.
We are able to hear you.
Yes. Continue, please. Continue.
Much obliged, Your Lordship. So through Article 19, Clause 1, Subclause A, every person has a right to freedom of expression, and religion is also a form in which they express themselves, and the practices that they subject themselves into is also under the ambit of Article 19, Clause 1, Clause A, Subclause A. And Article 21 guarantees the right to life and personal liberty, and the liberty with which they exercise to practice a religion is also impliedly being put to test through the imping statute. Moreover, Article 25, as already advanced upon by my learned co-counsel, and Article 14, as I right now mentioned regarding the fact that the procedure is
Counsel,
being levied
that's
upon
what we
only.
expect from you. I want to intervene here. What we are expecting out of you is,
Yes, Your Lordship.
even if you had raised only Shreya Singhal to us, I
Yes,
think
Your Lordship.
what my brother is pointing at, he's basically taking a cue out of your book. You're making things a little difficult for your own selves. Now, Shreya Singhal says one thing,
Yes, Your Lordship.
among other things. It says that you cannot prohibit anybody from doing anything if that poor chap does not know why he's being punished for that, or what punishment he'll go what he can how he
Yes, Your
can
Lordship.
pull his hand
Yes,
back.
Your Lordship.
If you would have gone through Shreya Singhal,
Yes, Your
Singhal
Lordship.
also says that if a person on whom we are going to penalize doesn't know as to which facts or which acts of his will eventually lead to such penal action being taken against him.
Yes, Your Lordship. Your Lordship, the argument pertaining to Shreya Singhal is what we've reserved for the third issue. So if you may.
Say it out. We have said you enumerate 2 and 3 together. Why
Okay.
why are you bifurcating?
I wanted to go in an order. I'll comply with that, Your Lordship. Yes, Your Lordship. So, with regard to quickly concluding on the argument for the issue 2, and then I'll follow up with issue 3. The right of self-determination and individual autonomy is also vested upon with every person. And moreover, the right to choice of an individual who has attained majority is also pivotal and can't be infringed. And the Article 25 clause 1 also provides for the right to not speak, and they can't be questioned under the same. Moving forward, Your Lordship, the Himachal Pradesh High Court, in the case of Evangelical Fellowship of India versus State of Himachal Pradesh, had observed ultra vires of a legislation pretty similar to the legislation that we have in hand of the Section 4. The Section 4 penalizes upon the all sorts of conversions that the Section 4 was held ultra vires, as it penalizes for involuntary conversions, which was held to be penalized. And moreover, in the case of Suresh Carlton versus State of Madhya Pradesh, the imping statute in hand was also found to be ex facie unconstitutional, as there was a declaration sought for under Section 10 of the statute of the case that dealt on Suresh Carlton. Now, drawing an analogy to both these cases, the council also like to submit that the decisions of the High Court, interpretations of the High Court in light of both these judgments, in a law which is pretty similar to the law we have in hand, shall also be taken into consideration. And
Council, you're not helping us. You have very limited time with you.
Yes, Your Lordship.
We got your idea of right to privacy.
Your Lordship.
We got the idea of Article 14, 19, and 21.
Your Lordship.
Tell us other pointers. Simply, we want to end up here. Your time is already 2 minutes left.
Much obliged, Your Lordship. Through the issue 3, we here to emphasize how the reversal of burden of proof is in a way imposing a guilt upon the person converting. And because And as rightly emphasized upon by your lordship, that through the case of Shreya Singhal versus Union of India, it has already been established that if the law in itself is vague and is not communicating on in which regard, in which light that the person is being penalized, then such a law can't penalize the person. Any vague law will be rendered void, is an observation that was made.
What you are missing out is right against self-incrimination. Which article prevents that?
20 clause 3, your lordship. I was
Yes. So
following on
this is
that.
this should have been your argument. Article 20 clause 3, because the procedure is in fact imposing
Yes, your lordship.
the unnecessary burden, and it violates Article 20 clause 3. I haven't cited it. We are saying it for your convenience. Okay, last point which I want to make to you, and I am going to ask this to both of the teams. If you have read two important judgments which you have cited in both of your memorials, one is K. Puttaswamy, other is Indian Young Lawyer Association Sabrimala verdict. Just mention the paragraphs. If you have read the judgment, don't misguide us. We know each and everything. Just mention the paragraphs of the judgment which you want to read in your favor out of these two verdicts. K. Puttaswamy and Sabrimala verdict, only these two judgments. Kindly tell us the paragraph numbers if you have read the judgment correctly. And this will be a question to both of the teams.
If your lordship may give me a minute to just
Yes.
consolidate all the paragraphs, and or should the team or the
So
council for respondents
what
go
we'll
first?
do is we are if my learned other friends are done with their
we can jump
query,
on to the other team.
yeah, so we can proceed with this query. Remember this query. When you are given time from rebuttal, start with the point that you want to read and stress on these two paragraphs from these two judgments. Okay, now we can have if my learned other friend Sitaji, if you are.
No. I believe let's hear for 1 minute on the
Yes.
issue number 3.
Yes, please go ahead, sir. Please go ahead.
Just 1 minute.
If I may go, much obliged, your lordship. Much obliged, your lordship. Thus, through issue number 3, the mandatory inquiry process is outrightly violative of the principles of natural justice, as it is not giving a due opportunity of presenting their side to the persons converting, and it is outrightly imposing a burden of proof upon the person convert. It is herein that I'd like to bring the attention of the court that it is the obligation of the state to establish the foundational facts, even in the principle of burden of proof. But in the facts of the case that we have in hand, the respondents have not outrightly established the involuntary nature of the conversion, but instead they have merely taken the use of allegations levied upon by the parents, and the aspect that a person is converting, there is a possibility that there occurs a reasonable bias at the end of the parents for the fact that they converted, and any such influences of the community, clan, or family shall not be taken under consideration, is also an observation that the Honorable Apex Court in itself had made. And moving forward, Your Lordship, the law we have in hand is creating a new form of vulnerable groups, as persons who are choosing to express themselves and convert into another religion are being subjected outrightly to a form of legislation, and any law which disproportionately affects vulnerable groups, we request that it is rendered void, Your Lordship. And the principle of audi alteram partem also must be taken under consideration, because the facts place.
One thing. What does audi alteram partem mean?
It provides the opportunity of being heard to both the sides, Your Lordship.
So they are giving an opportunity to you again. You have trapped yourself. Through district magistrate,
Yes.
I think he's holding an inquiry.
Yes.
So it means that if they give you
Once-
audi alteram partem, then they can pass any legis. What you are saying is basically you are arguing against yourself.
Your Lordship, going by the if I may answer, going by the facts that we have in hand,
The
we
facts
only
is
have.
not there. When my learned friend is asking you
What
something,
does audi alteram partem says? It says
It-
let the other party be heard. It's a part of the principles of natural justice, isn't it?
Yes.
Much obliged, Your Lordship.
How in this legislation, section 8, 9, how do they deny the opposite party or an affected person their right to be heard. In fact, that right to be heard is already in there. How the principle of audi alteram partem is violated once there is a provision for a reply by the concerned person.
Your
And if I
lordship,
may add, the issue is more about the burden of proof. You haven't said anything about how is it bad? Can you please elaborate?
much obliged, your lordship. Council first would emphasize on the burden of proof and then would take up on the principle of audi alteram partem and the link that we have
No,
to the
no.
case in hand.
First deal with the audio alternative button, then come to the other one.
Much obliged, Your Lordship. When the council said audio alteram partem, the reason why the council linked the principle herein is to emphasize that the person converting needs to be provided with a reasonable opportunity of being heard on the reasons why they are converting, and should not be presumably established that it's a involuntary conversion merely on the basis of facts, and there should not occur any presumption of facts that may occur, because it is often presumed that any sort, like, taking an example through the facts that we have in hand, merely because the marriage was round the corner, it can't be presumed that the petitioner did not have a bona fide intention of conversion. This is a leg of argument I wanted to make. Another leg of argument herein is, your lordship, that the decision of a person to convert it is being guided through the decision that the district magistrate shall make. Thus, there occurs a reasonable possibility that with an intention to protect the larger interests, the magistrate could
My dear, both of you have argued beautifully. My only issue with you, I wanted to I could not resist myself, but from sharing this, is that instead of relying and picking strength from your star arguments, you're going on to the arguments that should have been your number 2 or number 3 arguments.
So I
Am
think
I right,
Obliged, your
brother?
lordship.
I think we can switch to the next team.
Your lordship, if
But
I may be permitted to just
remember the query remember the query I made it from you.
Again
I
come
need
to you.
specific paragraphs of these two judgments from you at the time when we start with rebuttal. Now I think we can
One
Yes,
more
please,
thing,
please.
don't feel demoralized. What you have done is that you have so far performed well. I want to keep you upbeat and motivated. You're doing fine job. There's nothing wrong with it, but we are only pointing out issues that we thought should have been pointed out.
much obliged,
Now
your
we'll come
lordship.
to with permission of Mr. Harsimar, we'll jump to the other team.
Your lordship, if the
Sure.
council just has one aspect to request upon, can
You
the
will
council?
again.
Council, we'll do it again. We'll do it again.
Oh, much obliged, your lordship. Much obliged.
Speaker 1, 2,
TC40.
TC40, speaker 1, tell the issues which you are addressing straight away.
Yes, Your Lord. Much obliged, Your Lordship. The Speaker 1 would be addressing issue 1 and 2, while Speaker 2 will be addressing issues 3 and 4.
Let me sum it out for you. Let me sum it out for you. Your issues are irrelevant for us, because additional, if any issue would be there, we'll talk about that later. They have raised 3 issues primarily. That your legislation violates right to privacy as established under Article 21. Second, it unnecessarily puts a burden of proof on the other person for proving, which comes in the violation of Article 20, Clause 3, right against self-incrimination. Third, the process is basically ultra vires, that is unconstitutional. The law is not maintainable, is not sustainable. 1, 2, 3. 3 issues. Start with 1. Why it is not violative of right to privacy.
Yes, Your Lordship. The Council would be addressing on the issue of whether this legislation is infringing on Article 25, freedom of religion, as well as right to privacy, while my co-counsel would be dealing with the remaining issues. The Council for the Respondent submits that the Prohibition of Unlawful Conversion of Religion Act does not infringe on the fundamental right to freedom guaranteed under Article 25 of the Constitution of Bharat, particularly in the context of voluntary religious conversions. The Council requests your Lordships to please turn to page 11, paragraph 1 of our memorial. The respondent contends that this act is a legitimate legislative measure aimed at
Which
regulating
page number you are citing? Which page number you are
Page
citing?
11, Your Lordship.
Page 11 of your memorials.
Of our memorial. This act is consistent with the restrictions permitted under Article 25.
The Prohibition of Unlawful Conversion of Religion Act 2023 was introduced in order to protect marginalized communities who are being deceived into converting to another religion without an
I
understanding
want
of
to
their
throw
new
a
faith.
question at you. Straight away, I
Yes,
want
Your
to throw a
Lordship.
one. First thing I
Yes, Your
want to
Lordship.
understand what is the difference between Article 226 and 32.
Your Lordship, Article 226 is for a writ petition submitted under the Supreme Court, while Article 32 is for Supreme Court, while 226 is for High Courts, Your Lordship.
Which has wider jurisdiction?
Your Lordship, Article 226 has wider jurisdiction.
Which is more effective?
Your Lordship, it depends on the issue, but in generally it is Article 226. But in this case, we have
All
filed
right.
a
Now,
special
one more
petition,
thing.
Your
One more
Lordship.
thing. One more thing. You are basically defending an act of parliament, right?
Yes, Your Lordship.
I want to know how a bill turns into an act. Simple question.
Your Lordship, a bill is put forth, and there are discussions that happen in the Parliament regarding the case. And once it is approved by both the lower and the upper houses, it goes to the sign of the President.
And lower and the upper houses, is there some some ratio also, some minimum number that?
Yes, Your Lordship. Yes, Your Lordship. In case of a constitutional amendment, it is 2/3 majority, while in case of another bill, it's simply a majority of the Parliament.
Simple majority.
Yes,
You're
Your
saying
Lordship.
simple majority?
Lordship, it depends on the case, Your Lordship. It depends on the type of bill.
Say, for instance, assuming it's a financial bill.
Your Lordship, in case of a money bill, it only requires the majority of the Lok Sabha, where
All right, you can continue.
yes, Your Lordship. The Council would like to state that in page 11, paragraph 2 of our memorial, we have cited a Constitution Assembly debate by Sardar Vallabhbhai Patel, where he had stated that conversion from one religion to another brought about by coercion or undue influence shall not be recognized by law.
Council, we are aware of the judgment and debates. We have read your memorial through. It is
Yes,
fine
Your
to
Lordship.
quote and it is always a concern for everyone that any act should be in a public sphere should always be voluntary. It can't be Now, a very interesting fact has been raised by your opposite counsel that you are not born with a religion voluntarily, and a religion is basically imposed upon you. So is your
Yes,
caste.
Your Lordship.
So is your caste.
Yes, Your
Now,
Lordship.
let's say I'm 18, I'm well above the age of legal majorityhood. I read through I undergo a teaching by a teacher, let's say Granthi of a Gurdwara. I follow that particular Gurdwara. I want to convert to Sikhism. And it is, in a way, it can be said that I am under the influence of the teaching of a particular person. Yes, I am. But how is it not correct that despite that notion that I have been impressed upon by another person or a teacher, I am doing a voluntary act? How does state has the means to justify that? What are the tests? What is your test to justify that procedure? How do you draw a line? Again, this question comes
Yes,
to
again,
both the
I'll just
parties.
make things easier. I'll make things simpler. Say, for instance, I have a daughter who wants to marry a person from some other faith and wants to convert. What my brother is putting across is that, say, for instance, if I am not happy with her decision, it could be a private wrong between me and my daughter. Why should the state interfere? Why should it step into?
Yes, Your Lordship. Like the Council initially stated, this Act does not infringe on voluntary religious conversions. The inquiry process mandated under this Act, as well as the fact that the district magistrate requires a declaration, merely seeks to identify whether the individual has knowledge of the implications of this Act, which is conversion here. Say, for instance, the individual is forced into conversion through allurement. If your lordships could please turn to page 13, paragraph 11 of our memorial, we have stated the definition of allurement under multiple anti-conversion laws, where allurement has has threefold. First is any gift, gratification, easy money, or material benefit offered either in cash or in kind. The second point is employment, free education in a reputed school run by any religious body. And the third fold is better lifestyle, divine displeasure, or otherwise. These are the definitions of allurement. In this case, all the elements of allurement are being satisfied by Alex, as the conversion was not of his own volition but was
No, I
influenced
think,
by the
my dear,
temptation.
once again, the thing is, you may take these issues. My brother Harish and Simar can choose to agree with me, or give their displeasure to what I am going to observe is, my dear, what you are doing is that you are trying to basically defend an act of parliament, defend a law which has come into being, right?
Yes, Your Lordship.
And again, now just the issue that we face with the other team, instead of treating the path that is more safer, you're coming to your other points, point number 2 and 3, which should, we are not questioning it. Till the time we question whether that was right or wrong, we are, let us remain, because it is a huge issue. The law itself, whether it should have come into being or not, in the view of the constitutional mandate and in the view of various judgments, it is a question that the debate will be unending. You're coming to
Council, let me add to it. Let me put a very see, your burden is more heavier than them. Your
yes,
burden is to defend the
way
state.
too heavier.
Your burden is more heavier. Now, let me cite another example to you. Every marriage, I hope everyone on the panel or everyone in the audience agrees with the institution of marriage. How how it happens. Every marriage has that element of gift giving with each other. Sometimes, and it is categorized as dowry. Sometimes they are voluntary, sometimes they are involuntary. Involuntary, after all, has law and its prevention against it. Now, those gift givings are sort of would that amount to allurement?
Your Lordship, gift giving does not amount to allurement. Like the council stated, allurement has three folds, and if all these three elements are satisfied, only then it is
Yes.
considered as allurement.
Tell me, yes, I want to know those three elements. Now you are
Your
on the
Lordship,
point.
the council just stated, may you please turn to page 13, paragraph
No,
11
read
of
it,
our
please. We
memorial.
don't want to
Yes,
read.
Your Lordship. Yes, Your
Speak
Lordship.
them out.
Any
Read
gift,
it, read it.
gratification, easy money, or material benefit offered either in cash or kind, employment, free education in a reputed school run by any religious body, or better lifestyle, divine displeasure, or otherwise. Only if all these three elements are satisfied, it would be considered as allurement. And in this particular case, all these three elements are satisfied, considering the fact that Alex was promised a luxurious lifestyle, expensive gifts, and incentives. And more importantly, he was also promised a job, considering the fact that he was unemployed for the past 6 months before he decided to convert to their religion.
So, council, let me stop you here. Council, let me stop you right here only. So,
Yes, Your Lordship.
for a moment, let's just forget about this case. Take in consideration any marriage, any marriage, pan India, where a girl moves after marriage into her matrimonial home, she gets married. So, do you think that she should lead the status, the comforts which she left? Maybe if she's coming from a humble background, from a poor family, and she's getting married into a rich family, that she should not maintain the lifestyle of a rich family, which she can afford now, having been married into a rich family, but she should remain and maintain an outlook of coming from a poor family. That is for
No,
one. And for two, any woman who gets married, after getting married, she's free to choose for her own, that whether she wants to work as a job or join the family business, whatever, which in this case is that there is a family business, he's just simply joined it. So how can you say that this is an allurement? This is a normal routine of things in any marriage.
And also adding to it, counsel, for example, it might be your case that he has been given job as an allurement. Well, what if circumstances exist and a person coincidentally happens to have a job at that right moment from a person of the same faith to whom he is converted to, Wouldn't that be a crisis for the situation? Because you will strictly count it as a violation, as an allurement. But in fact, it is not a allurement, but a mere coincidence that that person got a job in a person of that faith. How does state how does state create an exception to situations like that?
Should a person refuse the job at such a time when the conversion process is undergoing? After all, he
Yes.
has to begin and
No, Your Lordship, may the council answer your questions? Your Lordship, the council here merely seeks to state that one is allowed to maintain their status, but in case a marriage comes with the condition of conversion, or if it comes with the forcing of somebody to change their religion for the purpose of gifts, this is considered to be unconstitutional. And converting for the purpose of marriage has also been held in the unconstitutional in the case of Sarla Mudgal versus Union of India. And moreover, giving gifts and alluring someone to convert are two different things, because like your lordship mentioned that in case of a coincidence there is no force or coercion used by the person on the other side in order for them to convert to another religion, while in the case of allurement they are attracted to convert to another religion by monetary or incentives otherwise. So only in
Just
case of
one second.
allurement.
Just 1 second now. Who should decide that these parameters of allurement or coercion have been satisfied? Say, for instance, if I
Lordship,
have
here
been
the
coerced,
district
just
magistrate
1
is
second.
deciding.
Just 1 second. Say, for instance, if I have been coerced, right, or I have been allured, would it not be for me to say that I have been coerced or allured? Why should the state bear the burden?
Your Lordship, like the council stated initially, the declaration submitted by the individual is for the purpose of ascertaining whether this, and then the magistrate conducts an inquiry into ascertaining whether there has been allurement or coercion. This is done merely not in this particular case, but this purpose is ensured merely to ensure that religious minorities are not being forced into converting to another religion where they don't understand the implications of their actions. As
Council,
stated
what you are suggesting is very dangerous.
Yes,
You
that's very
are you are in fact saying, let's say there is a faith called Baha'i faith. They have very limited population, very small number of population. And Parsis, for example, very limited number of representation as far as the population population consensus go. Now you are questioning the entire wisdom of one community. That you are so naive that your religion, being a religious minority, is so naive to not understand.
outrightly immature that you have not been able to grow
Yes.
to our level and find out
Why
that
doesn't
what the
why
faith
your concern does not happen to a majority religion? You have cited time and again saying religious minorities. It's a very dangerous argument. You are primarily questioning the collective wisdom of people, as
No,
if
Your Lordship, may the
they are
council
not
answer your
capable
question.
enough to give voluntary discretions. They are not able to understand voluntary discretions. That is very dangerous.
No, Your Lordship, that's not what the council meant to say.
No,
Your
council,
Lordship,
you
may the
don't have
council
to say
request
what you
for
have
what?
to say. It's the state you're
Your Lordship,
representing.
may the council request for more time to answer your question.
Please continue for a while. We'll grant time from your another speaker. So
Your Lordship, here the council merely seeks to address that this act was introduced in order to protect minorities. It does not mean that it was influenced, it was introduced only for the purpose of minorities, nor does it mean to say that this seeks to stop minorities from conversion. It merely seeks to impose that whether somebody who converts to another religion or a faith understands what they have converted into and understands the implications of their actions. That is all the intention of the act is.
Council, you have again stated that this act was enacted to, to protect the religious minorities. If you go to the Moot proposition, that
yes.
in the very first initial paragraph where the factual background is, there is no address about protection of religious minorities.
Yes,
Yes, that's what I was also. I wanted to point out where is she reading from.
Yes.
Your,
Yes,
lo-
you are
your lordship,
reading.
if you
You yourself have shrunk the objective of the act. Act itself does not.
Basically, what you have done is you have blown the lid off.
Your Lordship, if you look at the excerpt of the Act provided in the Moot proposition, it can be seen that the penalties imposed for converting a religious minority is much more than converting any other person, which means that this Act imposes harsher
My dear,
penalties.
then that also, I think it is
It is
clearly violating of.
outrightly discriminatory. You have created a bar. You have created a criteria.
No, what you have said is that one set of people will be more equal than the other set of people.
Yes, and this classification has no legal basis in our understanding. Either law should have catered equally to everyone, or it should not have. Simply.
Your Lordship, Article 15, Clause 3 of the Constitution does not permits the enacting of special laws for the protection of minorities.
So this is basically
But
under the
this law
guise of
has not
protecting
been
minorities.
enacted for
You are putting them
special
into deeper
minority.
trouble. You are
Your
putting them
Lordship,
into
here
deeper
a
Yes.
trouble.
reasonable classification is permitted for the purpose of enacting a legislation.
No.
Anyhow, Harish, we can move
The
on to the other.
classification.
Harshima?
See, the
Mr. Harshima, we can
the idea of intelligible classification exists
differentiate
only.
intelligible difference.
Differentia only exists in context of Article 14 and 16 when it comes to the grant of equal opportunities in terms of employment by the state. How does that classification come within Article 25, which is much more than the scope of Article 25, much larger than Article 14 and 16 for the reason it
Yeah.
encompasses into the right to private life. Right to private life, I think state does not have means to check whether a personal choice is a personal choice or not. Have you involved any psychologists? Have you involved any provisions for other social scientists to include into that test? You have not. The act does not include that. Act says a
Harishji,
DM, a district magistrate. For example, let us say a district magistrate has a agenda towards one particular community, personal agenda. Now, is there a check to that or not in a state or not?
yeah.
There is
Yes, Your
no.
Lordship.
So how do we ensure that the person who is using that power to declare a conversion illegal himself has all means and understanding and all wisdom needed to declare that particular fate? Okay,
Your
now
Lordship,
we'll
may the
put a
council
hold on
answer your
you.
question.
Mind, I think we can jump onto the other speaker also.
Yes,
Quickly.
yes, we'll
Yes, Your
go with the
Lordship.
speaker.
Into the debate. Speaker one, will again come to you in rebuttals.
Yes, Your Lordship. Much
You've
obliged,
done
Your
your
Lordship.
job well. Don't worry. You've done a beautiful job. Now we jump into speaker two.
Your Lordship, I'm
Speaker-
co-counsel 2 and I'll be dealing with issue
Now
number
you,
3, that
speaker
is
two, you have a very tight rope to walk on. Start where she left. Jump
obliged,
right
sir.
into the debate. Don't go round and round.
Yeah, sure, much obliged, Your Lordship. So the main question which is pertaining here is why the burden is proved on the accused. So, Your Lordship, if we look at the section 109 of the Bharat Sakshi Adhiniyam, which deals with the burden of proving a fact, especially within the knowledge, that is interpreted in the way that the onus of proving specific intention falls into the individual and not on the prosecution under the 106 of Indian Evidence Act and now 105 of 109 of the PSA. Further, it implicits that it applies to the case where the chain of events has been successfully established by the prosecution, from which the reasonable inference is made
Counsel, in this law has criminal implications. A person can be imprisoned and fined as well. Yes,
Yes,
it has overbearings of a criminal prosecution. And do you agree with me? Yes. In a criminal law under the Indian Constitution, an accused has fundamental right to remain silent. That burden only exists on the prosecution. How do you
Indeed, Your Lordship.
justify the fact, in fact, this law reverses that proposition of law?
Indeed, Lordship, I agree. However, here if you read section 109 of Bharatiya Sakshi Adhiniyam, it says the burden of proof is on the
Counsel,
prosecution. However,
Counsel, The act is a derivative of Indian Evidence Act. If you are stating the section 19, it merely defines
109,
what a burden of proof.
109. It's
Yes,
pointing out to
109 of
109.
Evidence Act. So you are basically saying what burden of proof is. In a
No,
criminal
but what she's saying
prosecution,
is, just one, let
in
me
a
understand
criminal
it better.
in a criminal
Hariji,
prosecution,
does she imply that now the burden has come on
yes,
to the accused?
yes,
No,
yes.
but she is deriving it from BNSS.
No, the new Indian Evidence Act, basically. Indian
Sakshi
Evidence Act.
Adhiniyam.
Yes, Sakshi Adhiniyam.
Yes.
Council, council
Are you
understand
pointing
the
out to section
basic
109 of which act?
Bharatiya Sakshi Adhiniyam.
Sakshi Adhiniyam. Sakshi
Sakshi
Adhiniyam.
Adhiniyam.
Yes. So council understand this fact.
BSA.
If we agree on the fact that it's a criminal prosecution, accused cannot be burdened with proving his innocence. Simple.
Your
He is
Lordship,
presumed innocent.
I agree with it. It is a general principle under the criminal jurisprudence. However, what I'm trying to say is the burden of proof is on the prosecution. However, where the section 109 comes here is where there is a specific intention is there that has to be proved by the person who is claiming it.
So
Here,
do you know the where it is used in criminal prosecution? It is used into the general defenses. For example, in a murder, in a case of assault, the other party alleges that I was not the aggressor. Then burden of proof is that the proof that he was not the aggressor is a burden upon him because it's a specific fact. Whereas in this case, what has happened is state has said that your conversion, state has already given a legal fiction. State has created a legal fiction by saying that your legal conversion is itself bad in law. Now establish how it is not bad in law. Otherwise, you will be prosecuted. So, by way of creating this legal fiction, what state has done is state has completely reversed the proposition whereby the accused does not have to prove anything, whereby now here an accused person has to prove that his conversion or his so-called adaptation to another faith is voluntarily. How that burden is justified.
Just one
Your
second.
Lordship, it is
Carry on. Try
Your
to
Lordship.
be very crisp.
Your Lordship, when you say that the prosecution has the burden, here the district magistrate has established foundational fact which is proving the guilt of the accused. Now it comes to the accused that he has to prove certain specific intention, and it is also applying that the chain of events has been successfully established by the prosecution. In the present case, the prosecution has successfully established the chain of event, including the circumstantial evidences and the testimony from which the
Counsel, wait a minute. So you refer to section 119 of BSA, right?
109.
109, yes. 109, right?
Yes,
109 or 119?
No,
109.
109. It says when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him, right?
Yes, Lordship.
No, and from this you are deriving that the burden of proof to prove that he was not guilty is on the accused.
Your Lordship, I will defer that intent, specific knowledge. Here, the specific knowledge why he is converting is the knowledge has with the accused here. So he must prove it. Why he is converting? He has the specific intention here to convert, which must be proved. So that state can
then the
infer that
counsel,
it is not force,
section
not force.
109 read with Article 25, which is freedom to religion. So once a complaint is raised and she repeatedly states that I have converted out of my own volition, out of free will. Now, where does the question of burden of proof lies? She's replied it again, and she is well within her rights. The Constitution grants her liberty. So that is why this whole thing, this whole enactment is unconstitutional. That is why the provisions of this act which you have enacted, we are willing to strike it down.
Your Lordship, if suppose if I am allured, I will definitely go and say that I am converting by my own wish. I will say because I am getting a material benefit from the conversion.
why will I? Then there needs the role of the state to come and check whether whatever I'm saying is correct or not by making an inquiry. And here in the inquiry, they have found circumstantial evidences which the petitioner is not able to disprove. That is why the conversion has been stopped by the district magistrate. If your lordship has no further question, I would move on to
Not
the.
convinced.
No, that is all right.
We are
That
still
is
not
all right. We can move
convinced,
on.
but
Yes,
if my
you
brother
can
judges
move
do not
on.
have any
You want
query,
to
you may proceed
give
to
a-
your next one.
No,
No,
so
don't.
we
You don't
are
want to
not,
carry
in
it any
fact,
further.
no,
109.
due to paucity of time, we can't say that we are entirely convinced, because
We have to quickly
ultimately,
move.
when it comes to criminal prosecution, counsel, you have to understand the fact the burden, heavy burden, is that of a prosecution. After
Prosecution, even
the-
defense doesn't even lead any. Even
Yes.
if it does lead minimum of evidence, it's okay.
yes.
Defense only says that I was not involved. That's all.
So basically,
Nothing is required. He has to puncture the story of the prosecution.
what this law has created a system whereby what we are understanding is that it has created a system whereby the DM
Rather,
is
we were
basically
surprised with your interpretation of section 109. I'm sorry, I was jumping into.
no. It's they are reading it from their side, but counsel, you have forgotten to read the other part of the proposition. Kindly go through the judgment of R versus Prabhu, a 7-bench constitutional bench, which deals with the burden and onus of proof. A prosecution is always under the burden. The defense is always under the onus, and the burden is always heavier on prosecution rather than the onus on the accused. So
Your lordship,
basically, so where in this situation what is happening is law has created an legal fiction whereby the law has already presumed that your religious conversion is actually involuntary, prove it otherwise. This burden is itself unjustified in our view.
Right. Now, one last question from my side. Here, I want to know, Shreya Singhal, which provision was struck down in Shreya Singhal versus Union of India? Same question I'm putting to you.
Section 66.
66. Are you sure it was 66?
Yes, sir. Yes, lordship. Your lordship, just to clarify what I meant with the section 109.
66 of which act?
Okay. Information Technology Act.
Was it 66 or 66A?
Sir. 66A. I apologize.
The problem with the VCs are that while you're looking at us, there could be other people around.
Anyhow, counsel,
You can jump on.
sticking to, we want you to say why your legislation is not unconstitutional. Tell us the pointers so that we can sum up your.
Yes. Quickly sum it up.
Quickly sum it up for us.
Much obliged, lordship. So, continuing with section issue 4, your lordship, if referred to page number 22 and para 35 of a memorial, it deals with the case Ramji Lal Modi versus State of UP, where the Supreme Court has emphasized that law regulating religious practice can be justified if enacted in the interest of public order, which Article 25 allows it. The judgment clarified that the religious freedom cannot be viewed in isolation from their impact on the public order. The need to protect individuals from being misled into adopting a faith through a false promise or a material benefit is within the scope of legitimate state's intervention. So now, why the act is constitutional and not unconstitutional, as the state has its legitimate interest in the interest in preventing such kind of conversions. Moving on, in the current case,
Ariji, I think speaker 2. I think we have heard what you wanted to say. We can move on to the next.
Some of the pointers. One is Ramji Lal Modi. You were saying
why I was intervening was that she is not summing it up. Basically, what she is doing is that she is going on a different direction now.
No, it's okay. Let her see. There is some time left.
That pointers be pointers.
So the first pointer is based on Ramji Lal Modi. You are saying though Ramjilal Modi, if I'm not wrong, dealt with the provision under 153A. They dealt with the complaint whereby a complaint was registered under 153A of the IPC, and the question of quashing of that complaint came in. And in fact, the Supreme Court quashed the proceedings as far as Ramjilal Modi is concerned. Anyhow, we take your point from the Ramjilal Modi. Second, so your second pointer is?
My second pointer is it deals with that right to conversion and right to marry also comes with the reasonable restrictions. It is humbly submitted that if we read at the Revenant Stanis laws of the state of MP case, it upheld the laws prohibiting the conversion by force, fraud, allurement, observing that these conversions in the cases were not a part of religious freedom but rather a form of exploitation. In the present case also, the petitioner's father-in-law alleged and his father-in-law promised to him give a business and expensive gifts, and also based on the circumstantial evidences, also the inquiry done by the district magistrate, it is served as a significant inducement. Further, when we deal with the right to marry, the state can impose restriction on right to marriage if it is the sole reason for the conversion. If you'll also please refer to the case Noor Jahan Begum versus the state of UP, which is given in the memo under para 43, it says Allahabad High Court has dismissed the petition stating that conversion from Hinduism to Islam was the sole reason. The sole reason for the conversion was marriage, without any knowledge or belief about the religion, which is not a good law. Here also, similarly, if we read the fact of the case, the petitioner's decision to renounce his knowledge and to convert into Christianity does not show his knowledge or belief.
Counsel, with this point, let me say, state has already enacted laws to regulate marriage. And this law does not deal with the facet, the law is with regard to the conversion. So unless, if let's say there is a marriage which is per se not valid or illegal, then there are specific statutes, I think, in effect already in place. So by this law, unless it uses the word marriage or attribute marriage to some allurement, I don't think this argument is in your favor. We don't agree with you, because we agree with the fact that state can regulate marriages, but there are already legislations in place. Now, if this law covers marriages under this act, kindly show us which provision of the act says that it covers the ambit of marriage also.
The law does not specifically cover the ambit, but it deals with the allurement, and here the allurement comes with the marriage. So, and also the petitioner counsel has argued this.
Counsel, I believe you were not here listening when we were, telling your co-counsel about this. So this bench is of the view that the allurement which you are saying, that this job and these gifts, these are a routine normal practices in Indian marriages, in whichever religion, whichever community you go. You may call it dowry, you may call it istridhan, you may call it meher or whatever. These are in common parlance. And rightly, as my brother Judge Harish has just pointed it out, this case is not about marriages. This case is about conversions, post conversions. So can you point it out where they have been forced or coerced or allured to get converted? Parents of a boy, of a groom or a bride not agreeing to the match for the reason of coming from a different religion is altogether a different story. But they never forced her that you first get converted, then only we'll consider. There is no hint about it in the preposition, right? So that neither there was a force, neither they were coerced, neither there was an allurement. She, out of her own volition, because she wanted to marry the love of her life, she chose to get converted. So whatever allurement you are citing, these are merely gifts. They have nothing to do with her conversion. Where is the proof of that? She's a grown-up adult. She can choose. That is the precise query. Now, please proceed.
Your Lordship, I feel there is a misunderstanding of the facts. Here, Taylor is not converting. Alex, who is the petitioner and who is Hindu, is converting into Christianity. And when it comes to the gifts and all, here it is mentioned that the father-in-law promised to give. In the general practice of marriage, I agree that it is a prevalent custom across the India where the gifts are given at the time of marriage. However, here if you refer, he's promising him to give a job. Why will he like come forward and give a promise? There is no need to promise him that I will do this, as the allegations and the circumstantial made that he is promising prior to the conversion itself. If we take this case, if they want to marry, we have the Special Marriage Act. There also he can go and get married, and then the gift can be made. However, it is prior to the conversion. The father-in-law is mentioning that he will be given with some job, expensive gift, luxury lifestyle, and all that, which create a potential allurement here.
Counsel, would you appreciate the position? Let's say these things would have happened post-marriage. We are saying the couple has married in this case, and as part of some personal choice or allurement, he converts after marriage. Would you still say that the marriage was actually out of some fraud or allurement?
Your Lordship, if there is a presence of the fact where it shows that he is out of his personal belief, whether he has read Bible, he is influenced by that, and that has happened, then there is a need for a specific fact or reason to believe that he out of his personal conviction is now converting into a different faith.
Okay, ठीक है. Your second point taken. We'll consider on that whether though we do not agree with the fact the act itself creates marriage or is trying to regulate the marriage. Marriage is already being regulated by separate legislations. I don't think this law pertains to that, and thus your argument will weigh if it at all fits here. What are the other pointers? Just sum it up. I think your time is also over.
Your Lordship, the only point here which is left out is Audi Ultram Partem, as already discussed by the petitioner, and as Your Lordship pointed out here.
And then
Hey,
again, Audi Ultram Partem.
My brother, let him speak. Let her speak. Let her speak. Whatever.
All right.
So, sir, the petitioner's counsel has claimed that the right to be heard was not given. However, if we look at the preposition and the facts of the case, when the inquiry initiated, then the allegations were made, and the petitioner has made his defense. And
one more
beyond
thing.
that,
sorry, Audi Ultram Partem also carries another corresponding duty of the state that nobody shall be a judge in its own cause. So if that was the case, then why the inquiry is being being put to for the district magistrate? Should it not have been? Should a tribunal not have been made instead? You're making tribunals. The state is making tribunals for every nook and corner of the city. New tribunals are coming up. Why this job has been given to the district magistrate? District magistrate is a part of the administration, no?
Indeed, Your Lordship, but here he has given
what
the judicial authority.
What my learned friend is trying to say is basically, is judicial magistrate capable of conducting an inquiry into the facts or not? Or rather, had it been granted to a competent authority like
Judicial.
a court of law, like
Yes.
a court of law, then this fact finding could have been happening. So this is a question to the state. It's worth pondering upon whether the state has given correct power to the magistrate to conduct such an inquiry into it. All right, we get your point. Also, I had posed the query with relation to specific paragraphs from the two citations which I am interested to know. I really want to know the specific paragraphs from two judgments whom you are saying we rely upon, both of the parties. If you have done that part, kindly cite us those paragraphs.
The council.
No, we are first dealing with T40 only. 40, have your researcher found those paragraphs?
Much obliged, Your Lordship.
T40, I'm asking T40. Speaker 2. Hello. Am I the only one left?
You're audible. You're perfectly audible. I think we have lost the network. with her. So we can start with T35 instead. Quickly.
T40 speaker 2, you are silent.
Your Lordship, will you please give us a time of 1 minute? We can refer to the compendium.
Okay, now I think, okay, now we can switching to T35. Specific answer, rebuttals only at the end. First, have you cited those paragraphs which I have asked for?
Yes, Your Lordship.
Only specific paragraph, those two judgments I'm asking.
Yes, Your Lordship.
Hmm.
So Council 1 would be dealing with Indian Young Lawyers Association versus State of Kerala, and my co-counsel would be dealing with Puttasamy. So in Indian Young Lawyers Association versus State of Kerala, in para number 111,
Triple
it
one.
is, yes, 111. It is
Any other para you want to rely upon?
para number 16, Your Lordship.
60?
16, 16, 16, Your Lordship.
116. Okay.
Yes, yes, Your Lordship.
Okay.
So in para number 111, the
Yes.
Honorable Apex Court is quoted, the notions of public order, morality, and health cannot be used as colorable device to restrict the freedom of freely practice religion and discriminate against women of the age group of 10 to 50 years by denying them their legal right to enter and offer their prayers at Shabrimala temple for the simple reason that public morality must yield to constitutional morality. This is the paragraph.
Okay, your second speaker about the Puttaswamy judgment, any paragraph you want to refer to?
Much obliged, Your Lordship. In Puttaswamy case, in right to think that has been vested upon through the judgment, the para number 81, Manupatra version.
No, but who is the author? Which author you're talking
A.K.
about?
Sikri, Honorable Justice A.K. Sikri, Your Lordship.
Okay, Justice Sikri. Okay. All right, para 81.
And for right to self-determination, right of self-determination and the right aspect of individual autonomy, we're referring to para number 465 and 471 of Honorable Justice D.Y. Chandrachud, Your Lordship.
All right, got it.
And Your Lordship, if the
Yes,
Lordship
sum up your
may
rebuttal.
permit,
Sum up your rebuttal.
Lordship, if before going with rebuttals, if your Lordships may permit, can the council emphasize on the point of burden of proof, which was also asked upon by your Lordships earlier on, but owing to paucity of
No,
time?
it's okay. We are convinced barely any time left. Just sum up your rebuttal. Include that your point in rebuttal as briefly as you can.
Much obliged, Your Lordship. There are no clear guidelines on what constitutes to willful conversion, which has been brought out through the impugned statute, and the Council for Petitioners have advanced certain suggestions in regard to the possibility to distinguish between willful and unwillful or involuntary conversions, Your Lordship. And in para 44 of the respondent's memo, they have as also observed by your lordships that they have mentioned upon religions and they have presumed of the facts as such. But in the moot proposition, there is no mention of the religion of either of the parties to our best of our knowledge. Thus, if the council if the as already discussed by your lordships in this regard, we just wanted a clarity from your from the other side, the learned counsel for the respondents in regard to whether which paragraphs have they outrightly used to presume to touch upon the religions that both the parties belong to, Alex and Taylor, your lordship. And additionally, with regard to burden of proof, your lordship, as discussed and mentioned upon by your lordships in itself, that there is outrightly a reversal of burden of proof, and even if there is such reversal of burden of proof, the foundational facts have to be proved by the state. They are at from there, and they are obligated to establish that there is an involuntary conversion, and allurement per se, the definition is outrightly vague, and the impugned statute, the provisions that we have provided with, does not explicitly define allurement as such, though though the through clarifications we were informed to make use of state legislations, but per se the definition outrightly is vague and subjective to interpretation. Thus, if they could also advance a definite
I think
definition for
I think your time is up.
Okay.
much
Anything beyond T40? Anything wants to add? Last bit, giving 1 minute only. T40.
T40. T40. TC40. Yes. TC40. Are you there?
Yes, Your Lordship.
quickly sum it up. TC40, speaker 2, speaker 1, anybody wants to say, can have a say now. Jump into this and finish it off.
Much obliged, Lordship. When the petitioner's counsel has asked the willful conversion and how do we differentiate between voluntarily or involuntary conversions. So here, the only measure we can find is by the declaration and by the inquiry. Other than that, there is no possible means to the limited knowledge of the council which can be used to prove that conversion is voluntary or involuntary. The act is only making sure the aim of the act is only to make sure that the conversion is out of his own voluntariness and not by involuntarily. And when we talk about the foundational facts, so this is what I was dealing with section 109 of BSA, that the foundational facts is being established by the prosecution, where the facts which are considered is the circumstantial evidences and the allegation and the testimony made by them.
We are not convinced with 109 argument. Don't bring it again and again. And the other aspect would be, I think that's it now. Rebuttals we have already. Is it over now?
The time for both the teams has lapsed entirely.
Yeah, time has lapsed.
So I believe, Brother Rajapal, let's conclude it now. I believe they both have made their good cases. So.
I just wanted to point out in 1 minute, I wanted to especially thank all the coordinators, everybody who's made this possible, especially Ma'am Charu Dureja, Ma'am Monica Sharma. We are obliged to them. We have always been very thankful to them, and today again, it is a very good platform to bring the students, an online platform to bring them at level and actually bring them face to face with the practical difficulties that they will face tomorrow when they come into practice. And for the teams, I think that there was, my brothers will also, I believe they will agree with me. There was a lack of bite. I think it should have been more aggressive. Both the teams could have been more aggressive and could have, instead of raising those issues and trying to convince us on issues that we did not want to get convinced on, they could have moved to the next point and always keep some templates ready. Say, for instance, even if you have to say that, I am not, I have limited knowledge, instead of saying that I have limited knowledge, say that I rely upon the wisdom of your lordship. So all these small things can be taken care of in times to come.
Thank you so much, sir. With this, I will request.
Yes.
I will request the judges to kindly share the score sheet with me or with Dr. Charu Dureja. After this, we will be proceeding with the valedictory ceremony. As soon as we receive the score sheet, we will be beginning with the valedictory ceremony.
Right. So we'll join back in.
Sir, you're not audible, sir.
I'm saying so. Are we free to leave now? I believe we can leave this meeting now, and we'll join back in again, right?
Yes, sir. As soon as you send the result, you can join back.
Yes,
Thank you so much.
Once we send you the results, right? All right.
Yes, sir. Yes, thank you, sir.
All right. It was lovely to hear both the parties. So they did well. All right. Thank you. Thank you for your assistance. Thank you.